Ireland did not provide state aid to Apple. This judgment annuls the Apple state aid decision of the European Commission of August 2016. Ireland has always been very clear that based on Irish law, the correct amount of Irish tax was charged and that Ireland provided no state aid to Apple. Ireland does not provide preferential tax treatment to any taxpayer. This is not the policy of any Irish government. It is not the policy of the Revenue Commissioner. And it was due to this that the decision was taken to appeal the decision of the European Commission to the General Court, and the decision today by that court and their judgment is a vindication of our stance on this matter. It has always been our position that no preferential treatment was given to Apple and that based on Irish law, the correct tax was charged. It's important to challenge the decision of the Commission, and it was important not to accept their ruling on that matter. And we did so because we believed that important issues had to be addressed, and we believed it was imperative to demonstrate that no state aid was provided by Ireland. The case involved, however, does focus on a period that is now of historical relevance only. The revenue opinions date back to 1991 and 2007. They are no longer in force. Ireland has already introduced changes to the law to deal with issues in relation to company residency. And we have made the necessary changes in our taxation regime as international tax rules have developed over time. As such, what I want to do is note the changes that we have already made. First, we have made changes to our corporate tax residence rules to prevent Irish incorporated companies from being stateless for tax purposes and shut down structures which allowed the exploitation of gaps in anti-avoidance rules. Second, we are continuously making changes to ensure that we are up to date with best practice on tax transparency and the exchange of information. We're one of only 23 jurisdictions to have been found to be fully compliant with new international best practice by the Global Forum on Tax Transparency and Exchange of Information. Third, we introduced country-by-country reporting in the Finance Act of 2015. Fourth, we agreed and fully implemented an EU directive to provide for the automatic exchange of information on advanced cross-border tax rulings. Fifth, we were among the first group of countries to sign the BEPS multilateral instrument, which sees the majority of our tax treaties updated to be BEPS compliant. Sixth, we agreed 2 anti-tax avoidance directives with our fellow EU member states in 2016 and 2017. Seventh, we agreed an EU directive to ensure access for tax administrations to information about beneficial owners of companies and other information held for anti-money laundering purposes. Eighth, we're only one of 3 EU member states to already have a mandatory disclosure regime in place. Ninth, we transposed the directive on dispute resolution mechanisms to extend the availability of arbitration when 2 member states disagree on where and how a taxpayer should be taxed. And then finally, controlled foreign company rules were introduced with effect from the 1st of January 2019. And this is in addition to the changes that were made in our transfer pricing rules, our anti-hybrid rules, and in ensuring we implement the directive on the mandatory disclosure of tax planning arrangements. That is our record in changing our corporate tax regime to allow it to still be competitive and also to respond back to the kind of changes we know needed to be made. They are the kind of changes that have been implemented here in Ireland. And as I look at the agenda that is ahead, I look at the debate that is underway in relation to the future of tax policy across the world and in Europe. I will continue to work closely on that agenda. It's my intention to pursue a constructive approach to the kind of issues that are being debated, that are being dealt with, and I look forward to continuing to work with Commissioner Vestager and the European Commission on that and other matters. But at the heart of the action that Ireland has pursued now over a number of years is reaffirming that all taxpayers are treated equally in Ireland. That is why we made the decision to appeal the Commission ruling on this matter, and it is why the decision now by the General Court is very important. Thank you.
Minister, you say that you're looking forward to working with the European Commission and Commissioner Vestager on other matters. Would that extend to moves that are reported to be underway to tackle tax planning using qualified majority voting as opposed to outright majority voting?
Well, I'm not going to comment on the detail of the proposal that has been shared by the Commission today, because it's only just been shared. They just had a press conference on it a few hours ago and are beginning to explain what that initiative is. So like any initiative that comes forward from the European Commission, I won't comment on it until I have understood in detail what they are proposing. Our concerns and our views in relation to the maintenance of unanimity in how certain decision-making procedures are followed are well known, but I'll meet Commissioner Gentiloni and Commissioner Dombrovskis in the coming months and talk to them in the coming weeks and have an opportunity to understand their views on this matter more. I've just detailed all of the change we've made here in Ireland. This is an agenda that at times has been difficult to convey and to gain recognition of. There are changes that we have made, and if the Commission are bringing forward new ideas on this or any other matters, I want to see them first.
Minister, in terms of the findings today, obviously, the Commission or the Court has found that Ireland has done nothing wrong, but would you accept that many of the changes that you've just outlined that have been made over the last number of years have partly come about because of this investigation, both changes here in Ireland and across Europe?
But the investigation and the ruling here today is, as you just said a moment ago, making clear that Ireland taxed companies properly. This is an agenda that we have proactively followed because we know change needed to be made. Yes, there has been scrutiny and focus on Ireland in relation to our corporate tax regime. That has been the case now for many, many years. And the balance that I have sought to create, and it's one that I followed, is making these kind of changes during my time as Minister for Finance, recognising the role of the European Union in really important tax matters, and also making clear that Ireland does not grant preferential treatment to taxpayers. And that has been recognised in the ruling of earlier on today. And I want to use this as an opportunity to recognise the importance of the ruling, but also convey our commitment to international tax reform and to note the changes that we've already made.
Minister, the case has been long running and it's generated, I think, about €8.5 million in legal fees. A lot of this has been paid, or some of this rather, a large proportion, 600,000 I think, has been paid to the current Attorney General. Can you confirm whether he will be continuing with the case and what the arrangements will be there in terms of his compensation for that? And secondly, do you envisage that there will be, related to that question is, do you envisage that there will be an appeal to the European Court of Justice by the Commission, and that Ireland will effectively be waiting for a judgment on this for another 2 to 3 years potentially?
So it's up to the European Commission and other bodies to decide whether they want to pursue an appeal in relation to the ruling of this morning, and it's up to them to indicate what their intentions are in relation to that. In relation to the matter of fees, the work of Mr Gallagher on this case predated his time as Attorney General, and his future role in this will now depend on if any other body decides to appeal the ruling, and if this matter develops during his tenure as Attorney General, he'll be handling this matter in his time as Attorney General and in a role as a public official. But as to whether that happens or not, Hugh, all depends on decisions now that others make.
Will he be paid legal fees for his work, or will he just draw down his salary as Attorney General?
I imagine any work that the Attorney General does is entirely covered by his salary.
Minister, here.
Sorry, excuse me.
How would you quantify the scale of the reputational damage to Ireland as a result of the original ruling by the Commissioner? And now that the Commissioner's ruling has been found to essentially have been built on legal sand, what's your sentiment at this point?
This is a matter that has caused reputational difficulty for Ireland during the many years in which it has played out. This is why the ruling of this morning is so important, because this matter makes clear that there was no evidence available to make the case that Ireland had granted preferential treatment to a taxpayer. It's a matter that I have been involved in now for many, many years. I have had countless engagements on, both in public and in private, and it is a matter that did affect our reputation while this issue was being pursued. But it is why the ruling of today is now important in making clear that we did not treat a company in any particular way. In relation to my sentiment about this matter, it's obviously really important from the point of view of certainty in our tax code and from the point of view of how we treat taxpayers. That clarity has been brought to this issue here this morning, and all of my sentiment is about that.
They call into question the credibility of the Commissioner.
I think Commissioner Vestager is a very effective Commissioner that I have a deep amount of respect for. I've worked with Commissioner Vestager now on many matters now over the last number of years. I have deep respect for her work and appreciation for the work she's looking to do in the European Union. This ruling today does not change my view of her, and I look forward to working closely with her now during her tenure as Commissioner in the coming years.
Minister, do you foresee the decision today adding to cause for an EU digital tax? Perhaps if some member states see that the EU's Commission or the Commission's competition arm is unable to tackle multinationals in this way?
I know the agenda in relation to digital taxation is as strong as ever, and it's not clear to me whether the ruling this morning will strengthen that agenda or weaken it, but in any event, it is very much on the agenda of the OECD and indeed the European Commission to find new and different ways in which digital companies can be taxed. And Ireland will have to play its role in the debate that will approach on that matter. I continue to be of the very strong view that the best place to reach agreement on this is in the OECD, and I expect, regardless of the consequences of the ruling this morning, that that agenda and that work will continue.
It's just following on, Minister, from that same question. Could you just reiterate what Ireland's opposition is the digital tax, and on the same basis, would you be able to reiterate opposition to any form of common consolidated tax across Europe?
Our concerns about digital taxation is that if this matter is viewed on a national basis and if it is pursued in a way that does not reach agreement across the world, that it's going to spill into trade difficulty. And we have already seen signs now of where some countries are responding back to taxation proposals in this area through a trade response. I believe the taxation of digital companies needs to change. I believe that as they get even bigger and as the number and scale of them grows, I believe that digital companies need to be taxed in a different way and in time need to pay more tax. But I believe the agreement on this is best found through the OECD. And in the engagement now that I'm having with finance ministers across the world, which began on Monday, it's very clear to me that there's a desire across the world to find agreement on that matter. And to go back to an earlier question, I expect the issue of the taxation of the digital sector and the future of corporate tax policy to continue to be a very active policy area for the rest of this year and into next year. And that's why I've outlined the work that Ireland has done in this. And then in relation to CCCTB, Ireland has long been of the view that it is a matter for national governments to be able to determine and set their own taxable base when it comes to corporate tax policy.
Could I just follow up there? Does this ruling not ironically make it more likely that some European countries will go their own way with digital tax or CCTB?
Well, it's very difficult on a technical level to see how you could go ahead with CCCTB on a national basis, because ultimately there has to be agreement with other trading partners regarding how issues of defining a tax base are going to be dealt with. So an agenda in relation to consolidate a tax basis on a practical and technical level can only be pursued in some kind of engagement with other countries. So I'm not sure how this particular ruling here this morning could affect that. And the ruling has just been made. I'm responding back at a principle level to respond back to our views on it. In the same way as if the ruling had gone any other way, I'd be here at this podium now, giving my response to it. And I imagine that one of the consequences of this is that care will be given to what are the legal foundations for pursuing change in this area. And maybe that is the most likely development of the ruling of the General Court this morning. But to reiterate, the debate in relation to the taxation of digital companies, the future of corporate tax policy, is going to continue. Change is coming. That change is going to affect all countries that trade in services, that trade across the world, and that agenda is going to raise decisions that Ireland will need to consider. And the ruling here today, while I'm indicating very strongly the welcome that we have for it because of what it means for how we deal with taxation matters in our own country, is also anchored in my view that there is going to be change in this arena in the coming years. Ireland wants to be a constructive contributor to it, and this will continue to be an issue in which there will be much work that needs to be done in Ireland on.
Minister, the judgment today was still critical of Ireland's how Ireland managed this in certain ways. And you mentioned that the case had damaged Ireland's reputation and why this ruling was so important. Do you think some of that criticism of that damage to the Irish reputation is stuck now, regardless of the final result?
I think the ruling that has been made here today will lead many to reassess their view of our corporate tax regime and some of the statements that have been made about it. And that is why the ruling of today continues to be very important. It's an issue that has been hotly contested now over many years. But the ruling this morning shows that Ireland handled this matter in the correct way. And I welcome that, while also acknowledging that this is an area in which debate will continue and a debate that Ireland will need to be involved in.
So you made reference to the fact that the two tax rulings, which form the core of this case, are historical, and then you outlined a series of steps that the state has taken since then. I think there was at least 10 to reform our approach to corporate tax. Is that in a way a kind of tacit admission that while the way we conducted ourselves historically may have been legally okay in the eyes of the General Court, there may have been something kind of morally or ethically wrong in the way we carried on in the past?
Well, actually, what it's a recognition of is that on countless occasions I've outlined the changes that we've made. And the agenda of change that Ireland has implemented has gained little traction in comparison to the criticisms of us that have been made at different times. And I think it's very important that I outline the change that we have made today, on today of all days, in relation to how our tax code was conducted and implemented in the past. We have a ruling here today that is making clear that our tax policy was implemented in line with Irish law at the time and was implemented impartially by the Revenue Commissioner. But what is the case, though, is the consensus in relation to international taxation across the years in which this issue developed is different now. We are in a different regime of debate and scrutiny. And where Ireland was many years ago, and where many other countries were many years ago, is now different to where we are today. And that is why I think it's only appropriate to, while welcoming the ruling that has been made and saying why it's so important for Ireland, I acknowledge what we've done, what I've done in the many different finance bills that I've brought forward, but also indicate to all of you that this is going to continue to be a very active area, and I anticipate much debate to come and much work ahead, and I'll play my part in that.
And you said that the ruling will lead many to reassess their view of our corporation tax regime. Do you think then that people who've been calling Ireland a tax haven for many years should apologise or perhaps reassess that view?
Look, I leave it to those who have been using that kind of language to decide whether was that you? Much of the criticism that has been levied at Ireland in relation to how we have handled the taxation of Apple has been given a very comprehensive answer today. And in the debate that is to come in the future of corporate tax policy and the taxation of digital companies, I think it's only fair to acknowledge that the ruling of this morning should have an effect on that debate, and also to, I hope over time, acknowledge the change that Ireland has already made. We have, through our participation in the General Court of the European Union, mounted a comprehensive defence of how we have dealt with this issue in our country. And the ruling this morning is a very important recognition now of how Ireland has dealt with this issue in the past. I've outlined what we've done in our more recent past on this matter, and I'm also outlining the commitment that I and the Department of Finance have to play a positive role in this issue in the future and to work closely with the Commission of the European Union. Okay, thank you all.